Thank you, Commissioner. Now it's time to get started with our first session on a very hot topic in North Carolina right now, workers' comp. Our panel will be discussing some possible solutions to the problems. And our moderator for this discussion is none other than Stuart Powell. So Stuart, if you want to come up. One point I do want to make, if I may. There was a nice article in the News and Observer today. I'll give Mandy I don't know Mandy Locke, but for those of you who didn't see the News and Observer, it was an article talking about this, with all the problems. So I'd encourage everybody to read it.
Thank you, David. Good morning, or afternoon, actually. I meant to trip coming up because last summer at our annual convention, our chairman stumbled as he came up, and the staff was instructed that we were supposed to sympathetically stumble as we approached the podium each time after that. So I'm sorry about that, but anyway. We've assembled, I think, a very distinguished panel to talk about some of the issues in workers' comp. It's a very broad-based panel. They have very different perspectives, and I'm going to introduce the panel. I'll make a few opening remarks, and then we've got some prepared questions for the panelists to discuss what's going on with workers' comp in North Carolina, both within the industry, externally, and legislatively. So give you some insight into some of the issues that are currently being thrashed out in the legislature. First, I'd like to introduce Mr. Mike Carpenter. Mike, if you'd come on up and sit down. He's the Executive Vice President of the North Carolina Home Builders Association, a trade group that represents the interest of more than 13,000 members of the home building industry. Mike first joined the North Carolina Home Builders Association staff in 1989 as Director of Government Affairs and General Counsel, and assumed the role of Executive Vice President in 2000. Prior to his affiliation with the association, he held posts with the North Carolina Attorney General's office and worked in the United States Senate for Senator Sam Ervin and for Senator B. Everett Jordan, very distinguished former North Carolinians. Mike has been consistently ranked as one of the North Carolina's most influential lobbyists in the by the North Carolina Center for Public Policy, and we're glad to have you with us, Mike. Next, I'd like to introduce Ms. Mandy Locke. Mandy is a reporter for the News and Observer. Mandy specializes in investigative and enterprise work on a vast range of subjects. Since joining the News and Observer in 2004, she has written extensively about the criminal justice system, child welfare, and the financial and political upheaval in certain area hospitals. In the last year, Mandy has exposed problems with employers who fail to carry workers' compensation insurance and highlighted the trends of businesses cutting corners to get ahead. And we're certainly glad to have Mandy with us. I would next like to introduce Mr. Rob Standen. Rob, if you would come up and take a seat. Rob is the president of Key Risk Management Services. He joined Key Risk in 2003 and has served as president since 2007. With over 20 years in the property and casualty industry, he has held various management positions with 2 regional carriers focused on workers' compensation insurance products and third-party administrative services. During his tenure at Key Risk, Rob has also led the claims and managed care operations. And last but not least, I'd like to introduce Ms. Sue Taylor. Sue, if you would come up. She is the Director of Insurance Operations for the North Carolina Rate Bureau. She has also served as the Rate Bureau's Director of Workers' Compensation, and in a previous life, she worked in personal lines with Allstate Insurance, Progressive Insurance, and Highlands Insurance, and for a short period of time was involved in the title insurance business. So Sue, thank you for coming. And with that, I'm going to move over to a seated position and begin to ask some questions to some of our guests. I would like to start out by addressing Mandy, and I want to take this opportunity to publicly thank Mandy for the work she did last spring and into the late summer on workers' comp. We know, because you deal with it every day, and you call me, and so we have for years labored silently with some of the challenges having to do with small workers' comp policies, particularly small businesses, and the whole question of who's an employee, who's not an employee, and some of the abuses of the system that we have witnessed over the years. And we have tried on various occasions to get some traction politically to deal with these issues, and we're just unable to do it. And thanks in large part to Mandy's work last year, she brought enough headlines to this issue to get state government engaged and interested in this issue, and I want to take this opportunity to publicly thank you for that.
Thank you, Stuart.
Mandy, these articles that you wrote last year, which really sort of got a lot of the ball rolling on at least getting these issues on the table for discussion at some very, very high levels in state government. I'm interested in what got you interested in this problem and sort of the methodology that you used to try to ferret out the information that ended up in your articles.
Sure. Well, first of all, let me just say it's great to be here. I'm not usually surrounded by a crowd of people who are pleased to see me, so thanks for the welcome change of pace. You know, about a dozen people have been blamed or thanked for sending me down this rabbit hole, and here's the truth of the matter. I very much accidentally stumbled upon something that you all have known and struggled with for many years. I was working on a completely unrelated story about the trend of how private companies are more and more using the public records law, a tool that journalists have used for years, to get access from the government. And in reporting this story, I came across a lawyer who had a client down in Florida who had been trying to get information from the Rate Bureau and the Industrial Commission about workers' comp policies written to businesses in this state. I found that kind of curious. I didn't know much about workers' comp. I've never been injured on the job, thankfully, and only been to the Industrial Commission once in my life. So I called this guy in Florida, and he told me about his business, which I really don't care much about. But he did say something really interesting to me. He said, Mandy, I think there's a huge gap between the businesses that ought to have workers' comp and those that actually do. So we got our own copy of the database from the Industrial Commission, and smarter colleagues than me started messing with the database and cleaning it up and trying to find out exactly how many policies are written in the state of North Carolina. We came to about 139 policies. Sue and Ray corrected me, and it was closer to about 140 at that point. And then from there, it was a simple math game. Nobody keeps a list of every business in North Carolina with 3 or more employers, which is the trigger, you know, for carrying workers' comp. If we did, this problem would be pretty easy to solve. But what we did use is 2 sources that gave us a pretty good estimate as to how many businesses ought to be carrying this policy. Our Department of Commerce says that we have about 170,000 businesses with 4 or more employees. And then Dun & Bradstreet, which is a business that kind of analyzes and studies businesses across the country, says that we have headquartered here in North Carolina about 172,000 businesses with 3 or more employees. So we came to the account of roughly 30,000 businesses were missing somehow. I actually now think the number's larger than that, and here's why. The North Carolina Rate Bureau has among their assigned risk 16,000 minimum correct me here, Sue. Minimum premium policies, ghost policies, I'll use the nasty word for it, in their system. And so if you assume that many of those are legitimately employer, no employee kind of businesses, then the gap between those that ought to have the insurance and don't is probably a little bit bigger. So that's the long and short of it, and I'm happy to get into the weeds a little bit more, but that's what set me on this path.
Thank you very much. Are you still looking into this issue, or have you moved on to other things, and sort of what do you see on the landscape from what you hear about changes coming down the road?
Well, you know, I've stirred up about as much as I can stir up on this particular issue, I think, and I'm pretty sure everybody's now schooled about the problem we have. The next challenge will be fixing it, which is a little bit above my pay grade at the News and Observer, so I leave that to you all and others in state government. I've not abandoned the issue of employee misclassification and continue to pursue some efforts there, so if any of you want to bend my ear on that, I'm happy to oblige.
For clarification purposes, the discussion, when they use the word classification in this discussion at the state government level, they are using it in a somewhat different sense than we use it. We use it in the sense of determining which premium grouping an employee would go into. They're using the term more generically in that people who are employees are being misclassified as not being employees. And that's what's stirred up so much interest at the state government level. So I noticed them using that word misclassification, and I've had to explain that sometimes to insurance people because we get a little, we have a much more narrow technical sense of the word than the way it's being used in general discussions. Thank you, man. We'll ask Mike some questions. Mike represents a pretty important constituent group when it comes to workers' comp. That is the construction industry, and more specifically in his case, the home builders. From your perspective, and you've been around the workers' comp area for a good while, what are some of the issues or challenges that the construction industry sees surrounding some of these issues that Mandy has identified?
Well, I think if you'd asked me that question 3 years ago, from the business community's perspective, what sorts of things what's the biggest problem facing the system, the business community would have answered that the system is badly out of balance and it needs correction. Not only with respect to what Mandy's saying, but the more fundamental aspects of the system. We clearly needed indemnity reform. We needed to restructure, frankly, the Industrial Commission and its mission. The cost to employers was too high, certainly on the medical side. And so the business community in 2010 sought to craft a legislative response to that. And in the 2011 session, House Bill 709 was enacted. It was negotiated, frankly, with the plaintiffs' bar and organized labor in an effort to reach a consensus, which we were pleased to be able to do. And some fundamental reforms were made that are very significant and that will not only control costs, but also put the system back in balance. On the indemnity side, among the things that were done was to try to improve the return to work provisions and suitable employment. Also putting a cap on total benefits at 500 weeks. But we also dealt with more legal issues of being able to control treatment, return that to the true purpose that the Act had upon enactment to allow the employers to have control of medical treatment to get employees back to work. And also the ability to communicate with physicians, particularly about the return to work aspects of that. With respect to the restructure of the commission, some fundamental changes were made there, as you know. The commission was reduced from 7 to 6 commissioners. Legislative confirmation was instituted so that while the appointments to the Industrial Commission remain with the governor, those appointees are subjected to legislative confirmation, which gives everyone in the process the opportunity to have input into that. And that actually, we had a commissioner, first commissioner, Tammy Nance, went through that process last session. And it was, by the way, unanimous confirmation. So the process worked as was intended. Likewise, some other reforms with respect to the way in which commissioners were switched between various positions. That has been prohibited. 2 6-year term limits for commissioners. And really importantly, the rules of the Industrial Commission were subjected to the Administrative Procedures Act. And that led directly to one of the other concerns that I mentioned, which is the cost of the system. And this past October, as a part of that APA process, the Industrial Commission had to adopt a new set of rules. And part of the rules is the medical fee schedule, which is not both hospital costs and physician costs. And we had the opportunity to object to the rule, to the schedule. In order to put a rule in effect on January the 1st in December, we all spent a lot of time arriving at a temporary solution to that issue, which resulted in significant costs, particularly on the hospital side. First of all, it froze the rates at June 30th, 2012, and then 15% reductions in outpatient charges and 10% reduction in, at least that's just temporary, and implants, for example, were capped at invoice costs plus 28%, where we'd been dealing with 400% or 500% markups on those. So, and this is an interim situation. This is subject to a comprehensive study that is going to be paid for by both the medical community and the employer community to arrive at what we hope is a fundamental reform on the medical cost side. Because, as I'm sure most of the folks in this audience are aware, the studies in North Carolina have shown that we're way out of whack for the rest of the country. So we're trying to get that back under control. With respect to the structural reforms, as has been reported most recently in Mandy's article today, there's an interesting piece of legislation that's already passed the Senate, Senate Bill 10, which would restructure a number of boards and commissions, but in particular the Industrial Commission. And if it passes in its present form, then all the sitting commissioners would no longer have a job, and that it would be up to the new governor to appoint replacements. So we'll have to wait and see how that shakes out.
One of the things that we've talked about over the years with medical cost and workers' comp, and Mike's exactly right, most of the national studies that have been done comparing workers' comp cost with other health care cost show that workers' comp is substantially higher. And part of the reason is you don't have cost containments in workers' comp the way we have in health insurance. There's no usual, reasonable, and customary. There's no deductibles, really. There's no co-pays. None of the things that we use as sort of throttles on health care have not been present in the workers' comp system, and it has allowed the system to get substantially out of whack. From the construction perspective, with this whole issue of employer misclassification, I know some of the people that testified in some of the hearings that I were at came out of some faction of the construction industry, and the question of the sort of the unlevel playing field that's been created in the industry, is that something that has been of concern to your group, your constituents?
It has been for many years. Obviously, as you've just put your finger on it, the legitimate businessman ought not to have to compete with folks who play by or don't play by the rules. There's a cost to doing business. There's a cost to obtain proper insurance coverage. There's a cost to pay your taxes. There's a cost to do all the things to comply with all the laws. And when someone's not, your competitor's not doing that, they're able to offer, they're able to undercut your ability to provide appropriately. And I think clearly there has been insufficient attention paid over the years to the issue of compliance with the law. And Mandy certainly, and the News and Observer, is to be credited for focusing this public spotlight on that issue. So clearly employee, I think it ranges, the employee misclassification issue ranges from actual fraud, where people are clearly doing it to get that competitive advantage, to perhaps more innocent mistakes sometimes in terms of misclassification of employees. We all understand that the IRS 13 issues or 7 issues, whatever it is, to determine whether you got an employee or an independent contractor, and I think if we all passed those around up here, we'd all perhaps have a different opinion about what all of them meant. So you could have some legitimate concern, but clearly there's a whole lot of folks out there that understand they have a responsibility to comply with the law, and they're not doing it.
Well, one other thing, Mike spoke to the Legislative Study Commission at one of the meetings a couple of months ago, and we were talking about a number of potential solutions to the problem, and you voiced a solution to sort of the 97-19 problem principal contractors and independent contractors from a perspective that was a little different than we had approached it. And if you wouldn't mind, I think our group would be interested in sort of hearing from you what you think a good fix for this problem is, because it was an opinion that I had not heard articulated before. It was interesting to hear.
Well, I mean, I think we were talking more specifically about ghost policies at that point, but I think to fix the problem, we're going to have enforcement. I mean, there's no other way to achieve that. And in order to have enforcement, we got to have resources. And clearly, the Industrial Commission's fraud unit, I think, has 2.5 employees. So they're certainly not in a position to make much of an impact out there. And let's face it, if you didn't have some highway patrolmen and some police officers on the road to enforce the speed limit, I think folks would drive a lot faster than they drive. And I think that's the problem. We don't have enough officers out there, if you will, checking to see if folks are complying with the mandatory requirements of workers' comp law. And I think that ultimately gets it's no more complicated than that. We're going to have to put resources into it, and we're going to have to get people out there to enforce the law. Now, clearly there can be a lot better cooperation between state agencies, and I think that's been well highlighted, and that was discussed in that study commission, where if you've got revenue out there looking, if you've got labor out there looking, if you've got employment security out there looking, there needs to be some coordination between those agencies. But ultimately, somebody's got to have the responsibility for enforcing the law. So I think that's really where we go. With respect to the ghost policies, clearly it's, as Mandy highlighted in her article, I think the first one, where you had I guess it was a framer who had all of his employees, bought them all ghost policies, and obviously that's an incredible misuse of the system, as the courts determined. But there is, as you all understand, a legitimate need for a ghost policy, in the sense that if somebody truly brings someone to the job site, if there truly are a sole proprietor contractor and they're fit the law, and they're not going to be able to get in right now under the law, you can exempt yourself, as we all understand, from coverage. And if a contractor says, I'm not going to have somebody on my job site that doesn't have workers' comp coverage, then that sole proprietor is going to have to get a certificate to be able to prove they got coverage if they choose to exempt themselves. But the ghost policies, as everybody in this room understands, is designed to protect not that person who's exempted themselves, but that person who's brought to that job site who may very well be injured. And so as a general contractor, you want that coverage. You want to be able to make sure that if the guy brings his brother-in-law to the job site and he gets hurt, that coverage is in place. So there is a legitimate role for ghost policies, but I think clearly what Mandy's exposed is there's also a tremendous possibility for abuse. And it really gets down, I think, ultimately to misclassification.
In the area of enforcement, as everybody in the room basically knows, the 3 or more rule has been around for a long, long time. It used to be 5, and then I think they changed it to 4, and now it's down to 3. For the last 20 years or so, it's been 3 or more. As long as you have an exception to the rule that employers must buy workers' comp, how does that complicate the enforcement issue? Because at some level, somebody's got to make a judgment or an interpretation of whether or not. The story I love to tell about that, there was a business in my hometown in my previous life as a retail agent. It wasn't a client of mine, thankfully. But I knew the gentleman, and he ran a laundry and dry cleaning operation. And there were 7 people working there. And his argument was he didn't have to have workers' comp because 2 of them were his sons and they didn't count. 3 of them were part-time and they didn't count, so he only had 2 full-time employees, so he didn't have to have it. Well, he got an opportunity to explain his theory to a district court judge, and I don't think the judge took it very well. So, but when you have an exception like that, doesn't it complicate the enforcement situation? And there are only a couple of states left, I think about 10 or 12, 14 states left that still have numeric thresholds. Is that something that we might need to consider in North Carolina to make enforcement more to enhance the enforcement and make sure that the playing field is level for almost all businesses?
Well, clearly it would simplify the enforcement. I think the challenge is political. I think you and I remember, Stuart, when it was four or fewer, and it was reduced to 3. The question is, can it go to 0? And I think politically there would be opposition from some small business owners to that. But I think certainly, to answer your question, obviously it would be easier to enforce if there was no numerical exemption.
But and the other aspect of the 3 or more rule that I think is somewhat interesting is, and the commissioner mentioned the level playing field issue. If you are a painter with 3 employees trying to compete against a painter with 2 employees, you're at a competitive disadvantage, plus the fact that you've got 2 employees who are uninsured, and raise the sort of public policy or sociological question of, should we have employees that are out there in the workforce who are not covered by workers' comp? And I wonder, do you see those issues percolating through the legislature in your contact with the General Assembly on these issues?
Well, again, 9719 is going to take care of that situation if that painter's with his 2 employees are employed by a general contractor, because the general contractor is going to have the responsibility for those 2 uninsured employees. So, the general contractor is either going to have to cover them through his own policy, or he's going to have to make sure that painter's got the coverage. But if the painter's out there working on his own for a homeowner, then you still got that same issue. Yeah.
Thank you. Let me turn to Sue a second. As I mentioned in the introduction, Sue is Director of Operations for the North Carolina Rate Bureau, and as we know, the North Carolina Rate Bureau does a number of things. But just for sake of discussion, I'd like for her to just remind us of the different areas they're involved with workers' compensation and with other things if she wants to, because one of the things that it comes up from time to time in this discussion, and it's come up in the legislature, is having public access to to information about the existence of workers' comp policies. And since the Rate Bureau is a repository of a great deal of that information, they are certainly going to be a factor or player in that. So Sue, would you remind us of some of the things you do, and then talk to us a little bit about this issue of public access? I know there are issues about how much information should be accessible and how much should not be accessible, and what some of you're sort of in the crossfire of that between the consumer and the companies, and sort of tell us a little bit about where the Rate Bureau is on those issues.
Okay. Let me just start out by saying that the North Carolina Rate Bureau was established by state statute. A lot of people think that we are a state agency. We are not. We're a partnership of insurance companies doing business in the state of North Carolina. Right now, we have about 500 workers' comp companies that are members of the Rate Bureau. One of the main roles of the Rate Bureau is to collect what we call policy and statistical data. First of all, policy data is information that we receive from the carriers in regards to all of the workers' comp policies that have been written in the state. So every transaction, and by transaction I mean a new business, renewal, change to the policy, cancellation, reinstatement, whatever, all of those transactions are sent to us electronically by the carriers. We in turn put all of that data into our system. We do a lot of things with that data. First of all, we use it to do rate filings. Statute requires that by September 1st of each year, we do a rate filing and file with the Department of Insurance. Another thing that we do is we promulgate experience mods that are used for the rating of the policy. We also provide that data that we receive from the carriers to the North Carolina Industrial Commission. We don't provide all of it, but there are certain fields like employer name, address, experience mod, and so forth that we feed on a nightly basis to the North Carolina Industrial Commission. The Industrial Commission uses that data to pay claims or to ensure that there's coverage for the claims. Something else that we do with the data is that once a year we provide a feed to the Department of Labor for employers that have experience mods that are greater than 1.5. So the Department of Labor wants to know about that so that they can institute some safety programs, training programs, and so forth. Another thing that we do with the data is that we compile a compendium of employers that are in the assigned risk market. Statute requires that we have a system out there so that agents, if they're interested in moving a policy from assigned risk to the voluntary market, they can have access to a listing of all of the policies that are in the assigned risk market. So what we do is we have a search tool on our website that allows agents to go in and do searches based upon the experience mod, the premium, the geographic area that they live in, and so forth. So different searches can be done to obtain employers that meet those criteria. Another one of the roles of the Rate Bureau is that we are the plan administrator for the workers' comp assigned risk plan. So this is the residual market, and those employers who are unable to obtain coverage in the voluntary market can obtain a policy in the assigned risk market. We also resolve disputes. We get disputes on employee misclassification, lots of different items, and I would say we resolve between 80 and 90 disputes during the year. We also do inspections, so if there's ever an issue as far as what the proper classification is for a particular risk, we will either go out and do that inspection ourselves, or we will contract with a qualified inspector to go out and do that. So as you can see, we collect a lot of data and we do a lot of things with that data. We take the security of that data very, very seriously. We want to make sure that we have the proper controls, and we do have the proper controls on all of that data. We want to make sure that only those that have a need to view it do view it. As a matter of fact, one of the changes that we recently made in my department is we used to display the Social Security number on our system so that all of our employees could view that Social Security number. We didn't want to do that any longer, so we have completely redacted, except for the last 5 digits, the Social Security number information. So we're trying to do things as best we can to make sure that we control the security of that data.
From the one of the issues that, as y'all know, I have been one of my crosses to bear for the last number of years has been the certificate of insurance issue, and I won't get started on that because I can't stop. But anyway, one of the problems with certificates of insurance is we have now in statute that it is an informational document only and cannot be used to modify, extend, whatever coverage is. And so it's pretty clear now that this document is only for information. The question is it real information? And we get reports from time to time of people, certificates floating to the top that aren't real. Somebody has taken an old certificate and whited out the dates and reissued it. Or a number of years ago, I think the Department of Insurance caught some people who were selling fraudulent certificates to minority contractors. So just because you've got a certificate doesn't really guarantee that there is a policy behind that certificate, which is a problem for contractors. I've been on the phone with a number of contractors over the years who got a certificate, and for some reason or another, the insurance got lapsed or canceled during the construction project, as something happens during that period of time of no coverage, and they're stuck with it, and they're saying, well, I had a certificate and I'm still stuck with it. So what does the consumer need to be able to do to check sometimes and see if those certificates are valid? And one of the suggestions that's come up is this public accessible database of workers' comp information. And are y'all engaged in that, and to what degree, and where do you see that issue going?
We are. Actually, the North Carolina Industrial Commission used to have a database out on their website that would give that information. However, one of the things that we found out is that that data was also being shared with data aggregators that would take that information and then sell it as leads. So what we did is we asked the Industrial Commission if they would take that website down until we could get a system in place to make sure that the data that was out there was proper and secure. As of right now, the only data that the Industrial Commission can put on a website is the policy cancellation date and the reinstatement date, which really doesn't tell the consumer much. There is a bill that has been submitted both to the House and the Senate now that would expand the amount of information that the Industrial Commission can legitimately put out on their website. And it includes the employer name, employer address, carrier name, carrier address. So if that bill passes, my understanding is the Industrial Commission will again put up their website that has that type of information so the consumer can go about determining whether their employer does have legitimate employer's compensation or workers' compensation.
Okay, Rob, you're not going to get out of this scot-free, okay? So,
I just figured out why I'm here, I think.
since you represent a substantial player in the workers' comp market in North Carolina, from the perspective of an insurer, an underwriter, a claims adjudicator on workers' comp issues, what are you seeing as the challenges in the workers' comp market? And also from an underwriting standpoint, where, from a company perspective, where do you see this issue of employee misclassification and some of these issues from your perspective?
Good. Talking about the challenges of workers' compensation, I always think it's important to start off really talking, especially to an audience like this, to really reset and rebalance is what was the purpose of workers' compensation? And really the fundamental purpose is, right, safety, prevent injuries from occurring from the people of North Carolina, people that are working. How do we prevent their injuries? And if they are injured, how do we get these folks timely, quality, reasonable, and necessary medical care as quickly as possible? And lastly, how do we return these people? Workers' compensation is meant to return these people to functional employment for the employers in North Carolina as quickly as possible. I think that's really a premise that sometimes we get caught up in all these things and we forget about that. So that's one thing I want to remind everyone before I go into the challenges. I think secondly is it's a commerce issue, plain and simple for the state of North Carolina. Let's face it, workers' compensation is a commerce issue. We're talking about the cost of doing business. And again, I believe we lose sight of the fact that today people are looking at, am I going to set up shop in North Carolina, or am I going to go across the border to a neighboring state or somewhere completely different? Workers' compensation, especially for a self-insured who sees the dollars day in and day out, is part of the business decision. So those are two things I always like to think about when we say, okay, now what are the challenges? I have a long list of things, but I'll keep it to four basic areas for this group. The first is interest rates. With the market we're at today, as a carrier, I think you all know you're seeing a change in pricing out there. What you read every day, workers' compensation rates are on the rise. I don't think our experience in North Carolina necessarily is on the rise compared to what it's been in the past. Maybe it is, maybe it isn't. But nothing drastic, but prices of the consumer are going up. And that's going on nationally. It's just not a North Carolina phenomenon. One of the reasons that is interest rates have depressed, they've declined. And in workers' compensation, where carriers are able to keep that money, earn interest on that in terms of income for a longer period of time, that actually is a big piece of the income. As rates go down, therefore also go down the returns. Basically, if I put it in perspective for you, for a 1% reduction or 100 basis points in investment returns, and that's really what the industry is seeing today, in a line like workers' compensation, the underlying loss ratio needs to improve 5 to 7% just to earn the same return for your shareholders. And at a time when many looking around this room have been involved with workers' compensation for some time, we all remember it wasn't too long ago that underwriters could actually underwrite workers' compensation at a combined ratio in the 100% ratio, 102, and still make a decent return. What's going on today to earn that same return, frankly, with where we're looking at, those loss ratios probably get down into the mid-80s, which is a price increase, which ultimately get passed on to the employers. So interest rates, that's a big challenge, not only for the carriers, but obviously for the employers of the state and all of you who are representing them day in, day out. Healthcare, I can go on, and I will come back to healthcare, but healthcare is a major challenge that is on, it's in the front view mirror for all of us day in and day out when we look at workers' compensation. I'm going to come back to that in a moment. Mandy obviously did a great job. I can't go on. I think she's highlighted a lot of the issues. I'm not going to go on record right here about those issues, but I can't do a better job than Mike and Mandy have done bringing those out to the forefront. And number 4, which kind of I think is going to begin catching more attention, I'm not sure many people have really thought about yet, is the assigned risk pool. The assigned risk pool over the last year the policies are up 9.3%, and the premium in the residual market's up 32% over the past year. Now I want you to think about this. Here we have an assigned risk pool that Sue and the team have done a great job of saying what their rates are, what they should be for those policies, and Commissioner Goodwin and his office ultimately approve those rates. But I want you to think about this. At a time when the market is changing and transitioning from soft to hard, and just market conditions alone are pushing more policies into the assigned risk pool, paying higher rates. And naturally, I think you're seeing in some carriers getting out of workers' compensation or really changing their appetites. What's going to happen? Well, we're going to have just naturally more policies, more employers going into the assigned risk pool, which the people writing the business in the state of North Carolina ultimately pick up the tab for that, and the assigned risk pool naturally is priced to probably lose money. Unless the rates stay ahead of that, this is what we kind of call in the industry a death spiral. If we start to get to a situation where the rates, approved rates, don't stay and keep intact with the assigned risk pool and the losses, what's going to happen is the state's going to see more carriers leave the state, fewer people are there to underwrite, and again, costs overall for the business owners begin to go up. That's just natural, and I don't think that'll happen. But now we talk about ghost policies and enforcement and making people have this. A lot of these businesses, let's face it, aren't into safety, risk management. More likely than not, more of those policies end up in the assigned risk pool. So I think it's a challenge, it's an issue that should be on everybody's dashboard, if you will, to be thinking about. But if we ignore that issue right now as an industry, as a state, we could be going down a very burdensome, troublesome road. So, what do we talk about? One of my first jobs in the industry was in loss control, risk control, loss management. And one of the first things I was taught in that role was get to the root cause. What's the root cause of the problem or the loss of the safety issue? I think now we're talking about wellness, healthcare overall. You still come back to, what's the root cause of healthcare and health? Get to the healthy person, not treat it with medicine. I really believe a lot of the things that we've identified here in the articles in the NNO, they're symptoms of a bigger problem. And I have to say this, Mike has done a fantastic job, but he's got a very difficult job dealing with workers' compensation as a lobbyist over the years. And I've sat in rooms with him, I've seen him operate, and I've seen the other special interests here. Very difficult job. I'm here to tell you, I believe the system is broke to an extent, and broke in a different way. It's not broke that we can't meet expectations, but really what we're talking about here is why don't all these people have workers' compensation? Why are they avoiding it? What are the issues? Well, it's very expensive. Workers' compensation is expensive, and ultimately the charged rates of the carriers or the rate bureau promulgates basically are developed from the losses. And I'll go back to, since I got into this business in North Carolina, workers' compensation reform has been an issue in this state. And while Mike did a good job laying out a lot of the issues and some of the changes that have attempted to be made, I personally believe it's been a lot of smoke and mirrors over the years in favor of a few special interests. I'll go back to 2009 when I sat on a industrial commission to talk about health care. Because really, when we get into health care issues and the rising costs of North Carolina workers' compensation, the studies you read, the WCRI studies, it still comes back to medical payments specifically being driven by hospital, inpatient, and outpatient. And this hasn't changed. That story hasn't all of a sudden new. It's been there for years and years and years. But yet, Industrial Commission, former Chairman Lattimore got a group together back in 08, 09, started looking at the issues. And just to make it really simple for you, the way hospitals charge in this state isn't a Medicare-based charge-based or a reimbursement system. It's a charge-based system. So whatever they charge, basically, for the outpatient treatment, we have to pay a percentage of that. So it used to be prior to 2009, it was 95% or so of the charges. And we sat around a table and nobody wanted to go into the Medicare. What it ended up getting was, we're going to reduce it. We're going to reduce it from 95 to 79. Implants then were a huge issue. We kept hammering implants at that table, and we were told we can't produce the cost of the goods. We can't tell you what the cost of those implants were because it's in records, it's here, it's there, it's all over the place. We were promised, a group came back, it's going to save North Carolina employers millions of dollars. And we know today when you look at it, in essence, that didn't happen because guess what happened? The charges just went up. So reimbursements, the costs continued to grow. So you're absolutely right, Mike, in this commission and things we talked about and some of these things. I'm not so sure when we ask the question now, how are we going to break out the cost of implants? We've been asking, we got no answer. No one's come, no one's sit down. So here we are on April of how we're going to adjudicate these bills, and still we're not getting any information. The reform that Mike talked about, you're right, there's a lot of things that we hope are going to change. But in all other states throughout the country, when you really look at reform, I think Sue will verify this, generally speaking, when you have a reform, you bring in some actuaries, right, to try and say, okay, what's the cost going to be, because what's the implied impact to rates? And Mike is absolutely right again. You know, most people talk about, hey, we got a cap of benefits. There's language in that law that there's no guarantee to a cap on benefits that we really know 9, 10 years from now we're going to be much different. Yes, there were some positives, but there were also some give and take. It was negotiated by many people. And at the end of the day, when the outside people, the actuaries come in and price out their reform, Sue, it was negligible, really no change. So I am here to say to you, and I'll take the contrary position, there's been a lot of smoke and mirrors. We haven't gotten to the root cause of what's driving the underlying costs of workers' compensation for the employers, and frankly, for a large number of injured workers out there, may not be getting everything they need. There are a few special interests that I believe have lost sight about what the intent, getting back to my original statement, of workers' compensation was. There are a lot of people making a lot of money off of workers' compensation, and I get back to it's a commerce issue. So I'll just, I guess, conclude this part of the remark with this. And Stuart said, when you talk about the challenges, what's the solution? The solution, frankly, is engagement. It's engagement from all of you and all the people that you represent. Going back to 2003, 2004 with some reform talks, 09, 010, 11, you talk to legislators, right? Who are the legislators talking to? They're talking to the lobbyists, out there hardworking people representing their groups. Then I get face-to-face with a legislator or 2 or 3 or 20, and I talk about the issue, and you know what they say to me? They say, Rob, I hear you. I got it. I've talked to this person representing this employer group, this person representing this employer group. But you know what, Rob? Look out there on the steps. Look at all those people that this one group brought. I go back to my office and I have a stack of letters this big that this is an issue and don't do this on workers' compensation, and they're from injured workers, different special interests. You know what I got from employers, Rob? The business people about workers' compensation? I got 5 letters. At the end of the day, they're looking at who's it an issue for, what's the issue? And none of this will ever change unless the business community gets fully engaged in the issue. Mike has a very difficult job trying to balance the interests. Stuart, do what's right out there, satisfy a lot of different people. But I will tell you, in my experience in this state, the ultimate solution is real reform, looking at all of the issues. It's not just a piece here, a piece there, and really, frankly, punting things down the road for 5 or 6 or 7 years. We see enough of that going on in other parts of our company, just punting the issue forward. It's a real issue for North Carolina business today, and I would really advocate all of you getting more engaged in it.
Thank you. Specifically now from the company perspective on the issue of ghost policies, employee misclassification, what are you seeing? What are your responses to this? What from a company perspective, how do we meet some of those challenges?
You know, it's one of those things that we've stayed away from because it is just riddled with potential fraud and passing on costs to other folks. I get really concerned, again, going back to the assigned risk issue with it. I think ultimately, no matter what happens, enforcement has to improve. When you start talking about, this is ultimately white-collar crime to an extent. And unless the penalties and the enforcement is there, behavior is not going to change. And ultimately, I think what will end up happening is, again, where we're at in the marketplace, these smaller policies, smaller groups of employees, I think are going to have a real tough time finding coverage. They're going to end up in the assigned risk pool. I don't really think it's going to be a private market answer.
One other question. Mike and I have been engaged with some conversation about a legislative change that resulted from a court case that came down last spring, kind of coincidentally with Mandy's research, a case called Gonzalez versus Worrell, which created some really interesting issues for us to deal with. And one of them was an interpretation by the Court of Appeals that unless a contractor got a certificate each time they sublet a contract, then they may not use that certificate as to eliminate their responsibility as a statutory employer of any of the employees of that subcontractor. So we've come to call that the job-specific certificate of insurance issue. And I think Mike's constituency, as well as you people who are my constituency, our constituency, probably are on the same page here. You don't want to issue all those certificates, and I don't think his people want to keep up with all of them. So from the contractor's perspective, is this a problem, and are we moving toward a solution to this problem?
Well, yeah, I think it is a problem. I mean, as you've already highlighted, not only the problem that you just discussed, but also the problem of what happens when you get a certificate, which we all understand is a snapshot on that particular day. What happens, 2 weeks later when the coverage is been canceled or through non-payment of premium or whatever it might be. But obviously, again, it depends on the relationship. If you have a subcontractor that you work with on a lot of jobs, it would be nice not to have to get a separate certificate every time you're going to have a job. But at the same time, what we want to make sure is we satisfy that responsibility under 9719 so that we're not, at the end of the day, we're not holding the bag for that liability.
Thank you. Questions coming up from the audience as to how the Affordable Care Act will affect workers' compensation. I'm going to defer that to the panel tomorrow because I don't know that we can answer that question. I have to deal with it a little bit, but there's a lot about affordable care I don't know. Thank you, Vince. Another question. Yeah, another question about the change or elimination of the 3 or more rule and the enforcement. We have talked about this 3 or more rule issue for a number of years now. Previously, I think Mike was correct that there were constituent groups out there that were would have been very strong opponents to that issue. I think at least from my perspective, the political landscape on that's changed a little bit. Those people not only are on defense, but they're basically representing a group of people who, in some cases, are actually violating the law. So I'm not sure how credible that kind of lobby might be in the legislature, given what's happened in the last year on this issue. But the statistics, the last time I checked, there were 14 states left that had a numeric threshold of some degree. Of course, North Carolina being one of those. Of those 14 states, 5 of them do not apply the numeric threshold in the construction classifications. So there's essentially only 9 states left that have a numeric threshold that applies also to the construction trades. So we are in a fairly distinct minority of states now. Many states have gone to basically everybody's got to be covered kind of mentality. One of the complications that comes in when you go that route, though, and we've had conversations about this, is what do you do with, one of the problems that we have is the uninsured sole proprietor. He buys a policy to cover his employees, but chooses not to cover himself or a partnership or members of an LLC or whatever, and then they get hurt on the job. I've had a number of phone calls from folks out in the field where you had that situation. You had a sole proprietor who had bought a workers' comp policy to cover their employees, but not chosen to cover themselves. They were now hurt, and they were looking for some general contractor's policy to go after, which is certainly not the way the law was intended to operate. And so one of the things we're going to have to deal with if this discussion comes up of eliminating the 3 or more rule is, what do you do about the sole proprietors, the partners, and the members of LLCs? And right now, it's an opt-in situation in North Carolina. And one of the suggestions has been made to flip that and turn it into an opt-out, so that sole proprietors, partners, and members of LLCs would have to be covered unless they affirmatively sign something indicating that they did not want to be covered, which would diminish the ability of them to try to claim under somebody else's insurance policy. So that's going to be a fairly political issue, I think, in terms of in considering the elimination of the 3 or more rule, what you're going to do about sole proprietors, partners, and because you could have if we do away with the 3 or more rule, we may be in fact institutionalizing the ghost policy, because we're going to require virtually everybody to have a policy, and there are a lot of businesses. You may have a sole proprietor, a computer programmer who doesn't have any employees. But the problem, though, is if he hires a helper for 10 minutes and they get hurt, then we've got the uninsured employee situation. So the ghost policy would be really the backstop to that kind of thing. But if they have to buy one, do they have to cover themselves? And I think there'll be a lot of political conversation about that. And so we need to probably think through that issue and make sure that whatever we come up with makes a lot of sense.
Yeah, I would add to that, Stuart, if the injury is bad enough, the plaintiff's lawyers are going to try to prove that sole proprietor was really your employee. Yes. And I think the reforms to the Industrial Commission... And not an independent contractor.
Yeah. I mean, over the years, as some of these issues have surfaced at the Industrial Commission level, I mean, the Industrial Commission has traditionally got a little heartburn over the proposition that I'm an independent contractor, but I only work for one person. And but the Industrial Commission over I'd say the last 15 or 20 years has been a very plaintiff-friendly environment. And that's one of the things the reforms Mike mentioned last year, and the reforms that are being considered this year is attempting to address, is the balance within the Industrial Commission from an employer-employee standpoint. And they certainly, the changes that were made last year tried to level that playing field by insisting that some of the commissioners have more of a business-friendly environment. But if we had a little bit more stability in the Industrial Commission from the standpoint of understanding the comp system the way it's supposed to work, some of those issues might have worked out a little bit differently over the last couple of years. But we'll see how. There's a lot of different moving parts to this puzzle right now, and it's going to be real interesting to see how all this plays out. I don't know that we'll get all the problems solved, but I am hopeful that given the legislative environment, there's a good chance that some of these things are going to get addressed in the legislature this year.
Stuart, can I add one thing on that point? As maybe being the only person in this room who's read hundreds and hundreds and hundreds of Industrial Commission orders, most often when they're having to decide the question of whether somebody is an employee or independent contractor, they're not necessarily distinguishing between whether somebody is a W-2 or 1099. Very often, the situation in which someone is considered misclassified, there was no 1099 issued. It was a wad of cash at the end of the week or a personal check written to the individual. So, you know, in legitimate cases where it's a 1099 versus a W-2, those questions are actually more complicated to ferret out.
Yeah, it is a very complicated issue. Last spring a year ago, I think, a case came through the Court of Appeals that I used in a workers' comp session I did in the CIC rubles that year. And it basically was a situation which appeared to be independent contractors. They were called independent contractors in their contract. They were told to go buy their own workers' comp policies. But because of the way the work was done, they were required to wear the same certain color shirts. They were required to drive a certain colored car. They had to do the work by very strict imposed guidelines. And to read that case and to read the Court of Appeals analysis of what it means to be an independent contractor versus employee is really kind of fascinating. And if you've got a person that is not allowed to use their own independent judgment in how the work is to be accomplished, I don't care what you call them, I don't care how you pay them, there's a good chance that the legal system is going to perceive those people to be employees. And that's where the real problem sets in. It is a complicated issue, and in North Carolina we have no statutes, no regulations on who's an employee, who's not an employee. It is a common law issue, and so it's really a legal question rather than an insurance question. Actually, more questions. Our time is up. We need to move on to the next session. I'm going to keep these questions, and I will try to get these questions. We'll get out a little white paper as quickly as I can get one drafted to respond to some of these questions directly. And I want to thank again our panelists for participating in this discussion on workers' comp. Thank you.